I'm going to start with the Equal Pay Act. 1963 basically argues men and women in the same job should be paid the same salary. So the Equal Pay Act, the intention of the Equal Pay Act is to ensure that women are getting paid the same as men doing the exact same job. And really, even for years after that, women were still told, well, you don't need to make as much as a man because a man is supporting a family and you're not. And so women were given differential pay even into the 70s and the 80s. Maybe less so now, although I still think it's kind of relevant. But certainly less so now. But it's still a concern. People are still making different pay because of, all sorts of problems around that. So, why did the law exist? Why does it only cover men and women and doesn't cover issues of race or ethnicity or religion or things like that? Well, because the expectation was, a year later, if you will, that in 1964 they were going to really try to tackle the civil rights legislation and deal with the issues of race, religion, ethnic origin, and color. Sex was not going to be a part of that. It really wasn't expected to be a part of it until significantly later into the 1960s and perhaps even into the 1970s. It was going to be pushed back. So, why did sex end up being a big part of that legislation? Well, because there was we call him the accidental feminist. There was a congressman who was really not interested in seeing this legislation pass. And so his intention was to add sex discrimination to the pile to either slow it down or grind the legislation to a halt. Because, the expectation was, well, people might entertain the idea of different races or ethnicities, men, having the right to work. There was still this stigma against women having that right to have equal jobs to men. Women were expected to be home and not intended to be in the workplace, at least certainly at that time. So the guy said, hey, we need to add sex discrimination to this, figuring it was going to actually slow it down or grind it to a halt. And in fact, it sort of had the opposite effect in that, people liked the idea and said, you're right, these are all groups that are historically discriminated against and they should be all included in this civil rights legislation. So let's add them. And so sex discrimination got added. But as I've already sort of implied from an earlier discussion in this lecture, adding sex discrimination to the pile became a challenge because it wasn't as fully developed as it could have been. And even if it was fully developed, I think there are still difficulties in anticipating all aspects of what might be considered sex discrimination. And it's one of the reasons why it took almost 20 years for sexual harassment, as I said, to be considered a form of sex discrimination, or pregnancy be considered a form of sex discrimination, or asking people about their spouses and their children, and that was a form of sex discrimination, or judging women on how much makeup they wear or whether or not they act feminine. That's a form of sex discrimination. And it's the same thing for men, too. If men are expected to act in a certain way or dress in a certain way, that's a form of sex discrimination for men, because there's an assumption that there's a gender role that men need to play, and if they don't follow that gender role, therefore, that would be a bad thing. And so when people get harassed for not following those gender roles or gendered behaviors, then they get harassed for that. That's a form of sex discrimination as well. So, your protected class is sex, race, religion, ethnic origin, and color. If you feel that an employment decision was made based on your sex, based on your religion, based on your color, your sex, your ethnic origin, you are protected under the Civil Rights Act. Right? There are special protected classes where we give extra scrutiny to cases where women, African Americans, Asian Americans, Latinos, and Native Americans are discriminated against. That doesn't mean that we don't care about the straight white male. What we care about is ensuring everybody gets protected, but we recognize that historically these groups in particular have had a long history of discrimination. So these cases get scrutiny and they get more attention. We're more apt to see these cases anyway. But absolutely, under no circumstance does it mean that white males are not included in that pile for legislation. In fact, that they are, and there are many cases throughout history where white men have sued under the Title VII of the Civil Rights Act and have won their cases because they've been treated differently because of their sex, because of their color. The last item underneath there is what we call a mixed motive case. And what a mixed motive case is where we may say something to the effect of, and this is a famous case. This is Hopkins v. Price Waterhouse, where we say to Price Waterhouse said to Ann Hopkins, "You're very abrupt. You're not really good with clients. Even though you do really good work and you're productive, sometimes you have a brusque attitude with our clients. The support staff doesn't like you because you're kind of rude to them sometimes." And that in and of itself might have been a good reason not to make her a partner or not promote her, in the accounting firm where she was working. But then they blew it. They turned around and they said, and you need to act more feminine, look more feminine, talk more feminine, be more feminine. And they blew it. And a mixed motive means you've got a reason that's legitimate, right? You're brusque with clients, you're brusque with support staff, and that's not appropriate. And then you have what we call an illegitimate reason or an inappropriate reason. You're not acting feminine enough. And so what happens is the illegal discrimination claim that you aren't acting feminine enough, or whatever might be the illegal claim, taints the legitimate claim. And it becomes very difficult to tease apart how much of the case is really based on the legitimate reasons and how much of it might be influenced by the inappropriate or the illegitimate reasons. And hence, a mixed motive case tends to rule in the favor of the plaintiff because, if it's tainted by this inappropriate association that they need to be more feminine or they shouldn't act so black or Latino and, stupid, stereotypes that people engage in, the bottom line is mixed motive means if it's partly bad, it's all bad. And while Ann Hopkins didn't originally win her case, it changed the way case law worked and interpreted the cases, and now mixed motives are an important part of interpretations of civil rights law. So just be aware, that when we give reasons for why we're not hiring someone, that we have to be careful of things that are based on including descriptions of things that are based on sex discrimination, race, religion, ethnic origin, or color. Even if we have some really good solid reasons to say we need to get rid of this person, you don't want to add in, and they're not feminine enough, or and they're acting too black, or whatever that is supposed to actually mean, which is ridiculous. But you hear people say that sort of stuff all the time. So just be really careful, in the language that you use. If someone legitimately should not be hired, regardless of their sex, race, religion, ethnic origin, color, don't add in other stuff that's irrelevant and inappropriate. You've got a good case that they're not doing a good job, then use that language to say they're not doing a good job. It's inappropriate for us to be adding other factors that are completely irrelevant because it taints it. It creates more of a problem for the company than anything else. So when we're trying to determine what is considered illegal discrimination under the Civil Rights Act, there are two different types. One is what we call disparate treatment, and the other is what I call adverse impact. You may also hear it called disparate impact, but I like to keep the terminology as different as possible. So disparate treatment and adverse impact is the way that I tend to describe both those categories of illegal discrimination. So we'll start with disparate treatment. Disparate treatment means that I am treating someone differently because they are in one of those protected classes. I'm treating you differently because you are Latino. I'm treating you differently because you're white. I'm treating you differently because you're a woman. I'm treating you differently because you're Muslim. You're in a protected class, and the discriminatory behavior is because you are a member of that class, whatever that is. So how do you make your case? How do you prove that there's illegal discrimination? Well, obviously the proof has to come through the evidence within the court of law, but in order for a case to go forward, the plaintiff has to make what they call a prima facie case, which means the plaintiff needs to demonstrate a number of different things. Number one, that they are belong to that protected class, that, you know, they feel that they were treated differently because of their race, their sex, their religion, whatever. They have to make that case, first of all, and say, I was treated differently from my religion, and here's the reasons why, to prove it. Then they have to say that they applied for a job for which they were completely qualified. How do you know whether or not someone is qualified for the job? Well, you know from the job description and the recruitment advertisement, which is why it's really important when we're advertising for recruiting that we're really truthful in what we want to see as the minimum criteria for people to come and apply for the job. So someone applies for the job for which they're qualified, and the organization doesn't hire them. Now, that in and of itself is not the problem, because organizations make important decisions all the time about who they're going to hire and who they're not going to hire. But where the catch comes in is either they hired somebody with lesser experience than them. Let's say you have to have a minimum of 5 years experience, and you find out that they hired somebody with 2 years of experience. Whoa, why is that? Or, you know, you applied for the job, you were rejected, and they're still accepting resumes. Well, if I've met all the minimum criteria, why would you continue to search for jobs and say that the job is still open when you've gotten my resume and you've told me you're not interested in looking at me as an applicant? This is not to say that there aren't legitimate reasons for the organization to do that. It's possible that they may have found out that someone has a felony on their record, or they had someone has inside knowledge about the candidate, just as we were talking about the other night, where someone says, oh, I know that person, and I know that they committed a crime, and I don't want them to work here. And there may be all sorts of legitimate reasons why someone might be rejected outright, although the employer sort of owes you an explanation, you know, because of this on your record, you're not eligible for employment. But to say, thank you so much for your application, we're not interested at this time, you know, it's not transparent. You're not really letting the person know the real reason why they're being rejected. And so it opens you up for, am I being rejected because I'm a woman, or because of my race, or because, you know, I happen to wear a headscarf and I'm a Muslim? You know, why is that? And so it really has to do with the time, you know, similarity of when some of these events occur. Obviously, this is not a simple checklist. Oh, I applied. Oh, I didn't get it. Oh, I'm a woman, so therefore it's discrimination. That's not the case. You really have to demonstrate that you had all the criteria, and that they still kept looking for people, or that they hired people who were less qualified than you. And that is the situation where you can turn around and go, you know what? That was illegal discrimination. You truly treated me differently because of whatever protected class I'm in. So you have to say that it's because I'm a woman, because of my race, because of my religion, and here's the reasons why. Here's how I can show that it was part of my religion. I wear a headscarf, so of course they knew I was a Muslim. So you walk in, you apply for the job, they don't hire you for whatever reason, and very likely don't give you a reason why they didn't hire you, and they may still be searching for somebody, and there's no reason why if you've met all the minimum criteria. The only legitimate reason would be, well, you saw me with a headscarf, so clearly you knew I was a Muslim, and you don't want to hire Muslims, you know. And to say that, you know, that sort of thing doesn't occur, I know it occurs all the time. I had a boss that I worked for who told me there were certain racial groups he would not hire, ever, and I had to handle that in a way that was really delicate. I always made sure all job candidates got sent to him, and he would make the final decision about who he would hire, but, you know, I didn't want to demonstrate that I was pre-screening people because of that. I was sending people up there, you know, very quickly and very legitimately, you know, all possible candidates to the president to make that decision. Unfortunately, they made some bad choices. I don't know if they ever got caught, you know, and had some problems around that, but nonetheless, that's something to always be aware of. I mean, it's a very difficult line to walk, you know, when you know that the people who are making the hiring decisions are discriminating, and you can say something to a point, and you either have to make a decision to leave or to be complicit in that activity, and that's not appropriate. So once the plaintiff makes their prima facie case that it seems to be pretty clear based on the proximity of events that I was not hired because I'm a woman, because of my color, because of my race, sex, ethnicity, whatever, religion, I mean, it seems pretty clear that was the relationship. Therefore, the burden of proof then shifts over to the employer. I mean, the EEOC or the lawyer comes in and says, hey, here's some facts. They met their prima facie case. Tell me what your reasons were for not hiring this person. Show me that there was a legitimate reason for not hiring them. And if you can't show me a legitimate reason for not hiring them, we're going to take this to court. And that's basically how the process works. So once they go to court, then of course the court makes a decision based on the facts, what's going to happen. But the burden of proof now falls on the employer to say, I didn't discriminate, and here's the evidence why I did not discriminate.